Alcantara v. Annucci. Alcantara, sorry, v. Annucci.
May it please the court, Your Honor, Matthew Freemuth on behalf of the appellants. I'd like to reserve 3 minutes of my time, if I could, for rebuttal.
Yes.
I think it's important to put this case in the context of the other Court of Appeals decisions on residential treatment facilities. There was Gonzalez in 2018 that took up the question of whether DOCS was adequately providing housing assistance. There was Johnson that considered whether an RTF needed to be a home-like environment. And then there was McCurdy on the same day that held that persons on post-release supervision after 6 months can be held in residential treatment facilities pending their ability to locate SARA-compliant housing. Now here we are. What is a residential treatment facility? This appeal presents the question of whether Fishkill satisfies the requirements of a residential treatment facility, or whether DOCS has the discretion under the New York Penal Code to operate the Fishkill RTF without providing access to community-based programming and in a way that is largely indistinct.
Can I just ask you, are you arguing that Fishkill could never satisfy the RTF, or are you saying that as currently constituted, they couldn't?
We are saying as currently constituted, they do not, principally because they do not offer any community-based programming.
Suppose they made an attempt, and I can ask your adversary about whether they have or haven't, but suppose they made an attempt to place individuals who are in the RTF because they're there awaiting SARA-compliant housing, and they were not able to do so. And the records show that there were, good faith efforts made. What then of your claim?
So if they made an attempt to locate or to provide community-based programming.
They went out, they looked for opportunities.
In and around Fishkill, yes, and they could not find any,
yes,
then Fishkill would be a non-compliant RTF.
And so in that event, is your view that, DOCS would have to put them in another facility?
DOCS would need to put them in a facility that met the definition of an RTF where there were community-based programming.
Go ahead.
The notion of community-based programming is definitional to what an RTF is.
So what I'm wrestling with is this. I take it that your argument is a combination of the definitional section in 2.6 and the provisions in Section 73, which relate to permission to leave and so forth, right?
Correct.
If there is an attempt made and it's not successful, it seems to me that reading those provisions to require DOCS to locate the facility in a different place or to move the individuals from that facility to another facility where those opportunities are available, I would think maybe we would want to look for some clearer instruction from the legislature, especially because it might be that with these individuals, it's difficult to place them in community opportunities. So can you help me with that?
Sure. I think, number one, I want to be clear that there is no record here that DOCS has ever made an attempt.
Yes.
And that is our fundamental.
I'm trying to understand your statutory argument, though.
Right. So look, Section 2.6 is the definitional statute, right? It says, from our perspective, that an RTF must be in a community. That has to be a community where educational and employment opportunities are readily accessible.
And was that enacted before the SARA housing requirements were clearly in place?
It was enacted before the SARA housing requirements are in place.
So what I'm wrestling with is it clear that the legislature anticipated, whatever set of challenges may attend this group? Or maybe your answer is it doesn't matter because the language is clear enough.
I don't think if my sort of timeline is right, when the RTFs were created and defined, I don't think SARA had been enacted, right? So they could not sort of anticipated it. But the fact that SARA has...
And with respect to the off-site opportunities, it also requires that there's a willingness of providers to have those opportunities made available to specific people, correct?
You would have to have a willingness of providers, but there's not specificity in the statute about who those providers are or whether other state agencies might
Right,
provide.
but it goes back to what Judge Halligan said. If they at least go out and they attempt to find engagement for, let's say, a specific person that's in the program, that they don't lump them all together, but they do actually exercise the discretion that it appears that they have, but they can't find a willing participant.
So, look, I think that raises, obviously, the question of if they don't have a willing participant, does this sort of definitionally meet the statutory requirements of an RTF?
And I thought you said it wouldn't.
I think, based on the definition of 2.6, you would have to say that in order to be an RTF, there has to be sort of community-based programming.
Now, that would apply, you're talking about, let's call them Sarah, people subject to Sarah, but this would apply to anyone in an RTF, right? Statutes don't distinguish.
The statutes do not distinguish.
So if you had someone who came and had a certain record and they just couldn't place them in Fishkill, that wouldn't be an RTF for this particular person in that RTF facility. It wouldn't qualify for that person.
I think whether a facility meets the definition of an RTF is not specific to an individual.
So what would it be?
Number. Sorry.
Yeah, that's the question. So what would it be specific to?
It would be specific to the issue of whether there are or are not community-based
But what if there's
programming
enough
available
for
for the residents.
30%?
Yeah, what if there aren't enough? There are community-based programs, I think this is
Yes,
the
it is,
question.
yeah.
But you have 100, I think, Sarah, people at Fishkill right now. What if there are only 30?
I think our position would be that would meet the definitional requirement of an RTF.
Why?
Pursuant
Because
to Section 2.6, because there are community-based opportunities. Docs
What
might then have
percentage would it have
discretion.
to be to meet the definition?
What percentage of individuals have to have access to that program for it
What
to meet
percentage? You said we said 30%.
What brings you into
percentage?
compliance?
Yeah.
the existence of community-based opportunities for
10%.
some portion of the residents of
Would 5 be enough to do it?
So you're hypothesizing a situation where there are community-based opportunities that only 5 RTF residents can take advantage of?
Yeah, I'm just trying to understand the scope of the requirement that you're
I
articulating.
think the scope of the requirement is that there must be some community-based opportunities. The statute doesn't specify how many or what percentage, but the record is
But
clear
you
here,
also
there are
have to-
none.
You also have to take into consideration who those individuals are. The programming's supposed to be made available for their reentry based on their circumstances. So these particular individuals in this program, they have some unique circumstances that have to be dealt with to satisfy the community part. But there's also an internal component where there's programming made available. So are you disputing that they've done nothing, or that the programming is partially compliant or not?
So I think our position is that with respect to the community-based aspect, they're statutorily non-compliant. And we also take the position that with respect to the programming offered within the facility, that also is non-compliant.
And why is that non-compliant?
The statute requires that the programming be specifically tailored, as Her Honor pointed out, to the individuals to meet their specific goals of rehabilitation and reentry into the community. And what the record below establishes here is that the programming offered really doesn't meet that requirement. There's not any specifically tailored programming. Most of the programming that's offered to RTF residents is programming that was available in the tail end of their determinant sentence, if you will, and so that they're failing, for the reasons we stated in our
I got the
papers.
impression that the programming taught budgeting, managing your financial resources, interviewing skills, and those all seem to be tailored to a reentry to the community. Is there something I'm missing?
I think the record is clear that there was nothing specifically tailored for individuals who were, facing challenges obtaining SARA-compliant housing or other challenges that those that particular class of persons
So
might
are
face.
you suggesting that in order for the programming to be sufficient, it has to meet certain minimum qualifications or have a certain minimum curriculum? Because it does, as Judge Annucci pointed out, there are things that do seem appropriate for people who are reentering society.
I think certainly one point is 73.3, which talks about specific programming being tailored to individuals' residents in the RTF. I think the record is clear that there is none of that.
Can we come back to your answer to Judge Canataro's question about the 5%? So 2.6 says that it defines an RTF as one where these opportunities are readily available for persons, okay? So how do you square that? I take it from your response to Judge Canataro, your position is that if the RTF makes a good faith effort, I appreciate your comment that there's nothing on the record about that, a good faith effort and is able to secure off-facility opportunities only for 5%, that suffices to meet the statutory obligation. Is that readily available? What work does that do?
I think it's a good point with respect to what the work is that the word readily does. I think it could be a question as to whether 5%, if they only had 5 positions open and 50 people in an RTF, whether that would meet the requirement of
I took Judge
community-based-
Canataro, I don't want to put words in his mouth, but to mean 5 out of 100, which is the number there, and that's
Right,
what I was,
5%.
5%. Which,
Right. I think there's a good argument that would not meet the requirement of readily available for the
So
members.
if it doesn't meet the requirement, then are you saying they have to take them out of that facility, put them in another?
I think they have to move them to a facility. If it is an individual who belongs in an RTF, for example, an individual like, let's say, the petitioner in McCurdy, who is now post-release, 6 months, being held there beyond the 6-month requirement, the only statutory basis to hold that person is in a residential treatment facility. It must meet the definition of a residential treatment facility. Otherwise, you're talking about incarcerating a person who served their time and for which the state has no basis to hold.
And by your definition, treatment is inside and outside the facility. It has fit both components.
But what if they
Correct, Your Honor.
move them and they don't get placed in the next facility? They try, but no placement in the next. What happens then? They have to move them again?
I'm not sure what you mean by if they don't get placed
They
in the
don't get
next.
placed in a community environment for anything. That's still the same situation. They try, but, no, they're still in the RTF.
They must be
Everything.
placed in something that meets the definition of an
And
RTF, which.
There's no opportunities in the next one, so that doesn't qualify as an RTF for them either, then, right?
Again, we're sort of, I don't think whether this is an RTF for them or not is exactly the question,
Well,
because
it is
whether.
for the 5% that got placed, right?
is your point that the right doesn't flow to the individual? In other words, that if I'm in an RTF and I don't get placed, that, I don't have a specific right, but when we look at whether the facility itself qualifies, we look as a general matter at the rights available?
Yeah, I mean, that is essentially the issue. It's a
But-
And then we
definitional
would
issue
shut the
about the
RTF
facility.
down? So then the RTF would shut for everyone if it doesn't qualify as an RTF, if it's not an individual right? I don't understand that
If it
point.
doesn't qualify as an RTF, then persons who should be placed in an RTF, I think, again, persons after 6 months of their post-release supervision present the starkest example.
Okay.
Then,
Do we have to answer any of those questions if the record, if we agreed that the record is devoid or lacks any information regarding what are the opportunities available near Fishkill? Or do you think the record is set on that? It's clear that there are no opportunities. It's not a question of whether or not they tried or not. There are just none.
I think the record is clear that there are no community-based opportunities at Fishkill within the meaning of 2.6.
So just to clarify, is your position that an RTF needs to make opportunities available for some percentage, maybe 5 is sufficient, maybe it's not, I don't know what the number might be or how we would identify it, and that the other individuals for whom the opportunities are not available can stay? Or is it your position that if I am at an RTF and there's no opportunity for me, docs must move me?
My position is is really a definitional position, which is to say, if I am an individual who should be in an RTF and I am at a facility where there are community-based programs available, then I'm at an RTF. Whether that specific community-based program that I'm talking
Even if
about
not
is
available
available
to
to
me.
me, I think is not this case, Your Honor.
Well, not,
I'm sorry. So just to go a little further on that point, then you're saying the universe is whether or not the RTF Fishkill, in this case, has in the vicinity, in its surrounding environs, possible opportunities for anyone who fits within that definition, even if everyone who is a SORA individual would not, and therefore fits within the definition, but, right, they are listed and registered under SORA, even if none of them could find a placement, or docs could not arrange a placement for them.
I think that's right, Your Honor.
Okay, so if all the others could find a placement, you would say it does or does not satisfy the definition, just to be clear?
I think if there is community-based programming available to some, readily available, then it meets the definition.
Even if it means someone who is a SORA registrant would not find a placement?
Well,
That's what I'm asking. I'm
Yeah.
sorry if I wasn't clear.
I think if there are a class
Yes.
for which there is nothing available,
Yes.
then as to that group of individuals, it doesn't meet the definition.
Thank you.
Good afternoon, Blair Greenwald on behalf of the respondents. Just to jump right in and answer the question that has been raised here about DOCS's efforts. Again, while not on this record, to my knowledge, DOCS has not made any specific efforts to secure outside employment opportunities because it believes it is not obligated to do so given the permissive language of the statute and given the fact that it doesn't have legal authority to secure third-party cooperation. It has focused the tools that it does have to get people out to community housing more quickly, which has successfully ended in a drastic reduction of the people
Your view is DOCS doesn't have to do anything other than what they've been doing here, the on-campus programming, but there is no community aspect to the RTF.
So there is a community aspect, and as the definition requires, that it be community-based in the sense of serving the general purpose of providing for rehabilitation and the goals of community reintegration. But that can be accomplished with programming inside and outside the facility, as the statute contemplates.
But 2.6 refers to a community where employment, educational, and training opportunities are readily available. You seem to be I don't know, downplaying that part of the statutory language. I don't know if it's a command on docs, and you can argue that it's not a command to docs to seek out and secure those opportunities for the people in the RTF, but it certainly sounds like it's more than just, being near a community.
So while certainly there is a siting requirement, and that siting requirement does serve the purpose of removing at least one obstacle to docs being able to exercise its authority to secure outside opportunities, we also agree that the definition does use the term community-based as a fairly broad descriptor that refers to the RTF residents as being based on or being about the goals of rehabilitation and community reintegration, but
That's
it's
not what
very
it
normal.
says. I'm sorry, you're not even close. You have read out of the statute the language. This is operative language. Community-based residents in or near a community where the listed types of opportunities are readily available. Why would the legislature write? Why would you have that?
Right, so just to address both of
If
those.
it means within the confines of the facility.
Certainly,
Which that's how I understood your argument. As long as it's within the confines of the facility, if it's got rehabilitative goals, then that fits within this section. But then you wouldn't have any language about community.
So the definition requires that it be in or near a community where these opportunities are readily available as a general matter, and not impossible due to lack of proximity to a community. So, a very isolated RTF that just would have absolutely no possibility of outside
Then
opportunities.
how could it be an RTF?
Right, so that would not be an RTF, and the reason why the legislature included this siting requirement was to remove that hurdle, right? Because they wanted to make sure that docs had the discretion to exercise its authority to provide outside opportunities.
Has docs made an effort to secure opportunities outside a facility at any RTF? Or
So-
only not at Fishkill?
So to my knowledge, not outside opportunities that are not docs facilities, and that is what petitioners are asking for here. So,
I take docs, just to be clear, I take petitioners to be asking for docs to attempt to secure opportunities that are outside the property of the facility itself. You agree?
I think both
In the
that.
community.
I think, yes, in the community.
Yeah.
And
so- Go ahead.
I'm sorry. I just wanted to say that docs has focused its efforts with the tools it has to get these people out to the community, and that is why now Fishkill has
Sorry,
an
what
RTF.
do you mean in terms of securing them, helping them secure
Sorry.
Sarah-compliant housing?
Yes, Sarah-compliant housing, which is why Fishkill now only has 19 RTF
Understood,
residents.
but I take it you're saying that at no, well, let me ask first, how many RTFs are there?
I'm sorry, I don't know the exact number. I think it's around 7.
Okay, and so your understanding is that at none of those facilities designated as RTFs has docs or is docs attempting to secure any opportunities in the community to work or have some employment training opportunity while they're in the RTF, setting aside the Sarah-compliant housing?
That's correct, Your Honor. Fishkill, I will note that Fishkill is certainly the largest RTF, so that is why the focus of
So,
this.
so I take it docs doesn't know what the challenges or opportunities might be should it choose to pursue that, since it hasn't done so?
Not as a, factual matter as of right now, but the important point here is that we're interpreting the statute and what the
understand.
legislature would have
So
anticipated.
just to be clear, before identifying a facility as an RTF, no one makes an assessment whether or not it could comply with the community-based opportunities requirement?
It does, Your Honor. So the RTFs have to be near a community where,
So there's an assessment that goes on before it is so labeled? That was my question.
Yes.
As opposed to we'll label it an RTF, then we'll figure it out.
right, so an RTF on a remote island would not fit the definition here.
So I realize none of this is in the record, but I just want to be sure that you're sure about what you've told us. My understanding is that there are RTFs, there's 2 RTFs in New York City. Is that wrong?
There are 2 RTFs where New York City is designated as sufficiently close to be considered the community.
Located in New York City, located within the 5 boroughs. Is that not right?
I think the 2 closest RTFs to New York City are Fishkill and Queensboro.
And
that can-
where's Queensboro?
Queensboro is actually further from New York City than Fishkill is.
And so there's nothing in the city itself, you think?
Not that has any substantial
RTF,
portion of
okay.
individuals, at least.
Okay.
I want to ask, I'm sorry, Chief.
No, go ahead.
I want to ask a related question to what the chief was just asking you. My understanding as well was that Fishkill was the RTF most closely located to New York City, putting it in my mind in the greater New York City metropolitan area. Now, I don't know how many, you said there might be 7 other RTFs. I'm wondering whether you have a sense, because I'm worried that if there aren't sufficient community-based opportunities around Fishkill, which is the closest to the major metropolitan city, that the other RTFs are almost by default going to offer even less of those community resources. So my question is, do you have a sense that if Fishkill wasn't compliant because there weren't sufficient number of community-based opportunities, or they couldn't secure them, would there be another RTF where there are more community-based opportunities or greater opportunities to secure them?
So I think Your Honor's concern about having opportunities available nearby is not so much related to Fishkill's distance from New York City, because the Beacon, Poughkeepsie around Fishkill, those are also used to meet the geographic siting requirement. What we are concerned with here is that it both meet that definition of being near enough a community that, as a general matter, has opportunities available, and the legislature's understanding that for certain populations of the RTF at different times, it may be impossible for docs to secure such opportunities. And correction law section...
Are you saying it just has to be near a community, but no actual opportunities have to be made available?
So there have to be opportunities that are generally available, as the
Generally
definition...
available to whom?
To people on community release or eligible for community release. And this shows the legislature's aspirational goals of allowing docs to the
And what's
extent...
DOC's responsibility with respect to said availability?
So docs' responsibility is to secure these opportunities regardless of their location. So that is
What does that mean?
That is in section 73, 2.
I think
And
one of the
it-
things you said at the very beginning, when you were going really, really fast, so I may have missed it, was that DOCS has no legal authority to work with outside third parties.
Sorry, no legal authority to force private parties generally to cooperate.
Oh, but you're not saying you don't have an obligation to try. You just can't compel them.
Well, we also believe that there's no language in the statute that obligates docs to try, and the legislature knows how to do that. In section 2015, which the court looked at in matter of Gonzalez, that talks about docs shall assist
So
these
it's correct
individuals.
that you're focusing on the location of the RTF near a community where opportunities are generally available. As long as that's done, DOCS doesn't have to lift one finger to even try to help even one person. Is that what you're saying?
So that is correct, but that's because the legislature wanted to make sure that docs' authority wasn't just entirely a nullity just because of this
Okay,
lack
so-
of
So then
proximity
what
to a
does section 73, because you had mentioned it before, 2 mean when it says the department shall, it doesn't say may, not could, decide on its own, discretionary, shall be responsible for securing appropriate education, on-the-job training, and employment for incarcerated individuals transferred to RTFs. You're saying that that training doesn't have to be community-based? Is that the way you read that, just to clarify what you think the point is of 73-2?
So it's community-based only in the sense that it's directed toward these goals of rehabilitation and
Okay,
reintegration.
so then
It doesn't-
what's the point of the second sentence? The department
Right.
also shall supervise such incarcerated individuals during their participation activities outside any such facilities and at all times while they are outside any such facilities.
Exactly. So section
You're
2,
securing the opportunities, and you got to supervise them if they're outside the facility.
So Section 2 imposes these fairly burdensome obligations on docks to secure the opportunities and to supervise them at all times while outside. And to compensate for those burdensome obligations, the legislature made permissive the fact that docks may secure these opportunities outside. And the permissive
Where's the
language
permissive? That's what I'm saying. Where is it permissive?
in 72.6 and in 72.1. So the two places where they talk about what individuals being able to go outside, in section 73.1, it says that such person may be allowed to go outside the facility. That is regarding docks' authority to allow them outside. And 72.6 talks about an incarcerated individual of an RTF may be permitted to leave such facility in accordance with the provisions of
But
section
isn't
72.
that essentially making sure there is discretion available to docks for appropriate individuals, not just having discretion that you don't utilize?
That broad discretionary language is both entirely in line with what the legislature normally does when granting agencies authority to design and operate programs, and particularly in the context of corrections, where the department has.
No, that is clearly understood. Docks doesn't have to let just anybody out into a program after an individual assessment where they find that they would be inappropriate to participate in a particular program because of either a danger to the community, something in their background, or something that occurred on the facility. They don't just have to let them out, but what you're suggesting is they don't ever have to let anyone participate in anything or supervise them anywhere.
That is correct according to the language of the statute. And what Your Honor mentions about, a particular individual not being appropriate, that actually is a separate provision of 73. That is in 73.4, where docks may suspend such program for such an individual.
I want to make sure I understand what you're telling us docks' process is. So what I took you to say is that in the course of selecting an RTF site, the docks does assess whether there are opportunities to go outside the facility into the community and engage in employment or training. Is that right?
So yes, but I want to be clear that the general analysis is that it be near a community. And
Those are very different. Is there any, I understand near a community, that's a question of proximity, but is there any analysis that docks does of whether there are, in fact, potential opportunities out there for individuals to leave the facility and work or be trained? If you know.
In the sense that the community, as a general matter, would have, jobs available.
So docks is assuming because there are different kinds of commercial, stores, whatever, operations, that there might be opportunities.
Essentially, yes. So docks doesn't do a targeted search to make sure that the particular individuals at the RTF at that time will be able to access or, be able to secure particular opportunities in that community at that time. And that, again, makes sense with what the legislature intended here, because it's, not clear at any one time what type of population is going to be in the RTF, what type of opportunities docks will be able to secure. And docks is held to a more onerous standard of actually securing those
Counsel,
opportunities.
I just want to get back to 73.2 for a second. Is it your position here that docks complies with its obligations under 73.2 by providing education, on-the-job training, and employment entirely at the facility and not in the community?
Yes, as long as it meets all of the other requirements under Section 73.
Thank you.
Just a few points to address fairly quickly. A common thread through many of the questions was the difficulties that docks may face in locating or identifying community-based programs. With all due respect, that is not a basis, difficulty or not, to shirk what is a statutory requirement, which is to provide RTF residents or define an RTF as something that includes community-based programming. And also, there is no record to support that either Docs has attempted to do so or that it was difficult.
But would
But
it be
is
enough
that
to?
really a statutory requirement? I mean, 72 and 73 say residents may be allowed to leave the facility. So shouldn't we just let the legislature amend that to must, if that's really what they meant?
I think you can read 72 and 73 and the use of the word may entirely consistently with the definitional requirement that an RTF include community-based programming.
But my
72
understanding is that you're saying must in terms of must have a placement, not must make reasonable efforts, right?
There must be community-based opportunities, correct?
So would it be enough to say they have to make all reasonable efforts to secure community-based opportunities, or no?
I don't think that would be enough.
Why not? Why isn't
Because-
the effort enough?
Because the Section 2.6 says that those community-based opportunities must be readily available.
But what about the
if those
component that Docs doesn't have control over, which is private industry?
If the community-based opportunities are not readily available, then it doesn't meet the statutory definition of an RTF.
So do they close the facility?
They can't label it an RTF. Because at that point, it is essentially a general confinement facility that they've labeled an RTF.
But if
There must be a difference
Five
between
people in
those
that
two.
RTF can't be placed because there just are no opportunities for them. They have to close the RTF for everyone?
No, I think that gets to the question of whether the opportunities are readily available at that facility.
There's also authority, I thought, that Docs has to say that some individual person is not appropriate to participate in the program. And presumably, if there is an individual, but tell me if you have a different view, an individual who, for whatever reason, is someone for whom Docs cannot find a placement, that isn't there an argument they would fit within that exception?
Yeah, I mean, I think that gets to the issue of Docs' discretion, right? We don't dispute that Docs has some discretion around the circumstances and conditions
So you're not
that an
saying-
individual can be in the community, right? That's effectively what 73 establishes.
So therefore, it seems to me that it's not the case that every individual at an RTF would have to, in fact, be placed for it to qualify as an RTF, or do you?
Correct, I agree with that. I
But
agree
that
with that.
What you
Provision,
take, is it correct that what you take exception to, and what it appears that the respondent acknowledged, that they don't have any obligation, and they're not making available across the board? Is that the problem?
That is exactly the core issue. They cannot exercise discretion to such an extent as they have done that effectively redefines an RTF into something that's not recognizable under the statute.
Thank you.
Thank you.